Hi, so welcome back to drug school. Today we're going to go back to high school government class and we're going to have a little civics lesson to introduce pharmacy law. Welcome to drug school.
So, welcome back to Drug School. My name is Adam, and I will be your host for this lovely lecture today. It'll be on pharmacy law. And never fear if you accidentally landed here because you needed a U.S. government primer, you're in the right place because that's what we're going to be discussing today. And while I'm going to be doing a lot of this in context of how pharmacy law is created, I wanted to just go back to civics class for a minute because pharmacy itself is the most regulated profession. And if you don't believe me when you hear that concept, go take a look at the Board of Pharmacy in your respective state. And you'll find that on a regular basis, several healthcare professionals on a monthly basis face disciplinary action from their boards of pharmacy. And in a lot of instances, those acts are intentional. Now, there are a certain subset that accidentally commit a violation of the law, and they really didn't intend to do it. And when we get to the last slide, you'll understand why that can accidentally happen. So, who really gets involved in making a law? Well, most laws are passed by legislation. That means Congress passed a law, the legislature passed a law. So if Congress passes a law, that would be a federal law. The legislature passes a law in your state, that becomes a state law. Your local councils can actually pass local ordinances, and those do have a little bit of effect on the practice of pharmacy, and we'll get into that in a little bit. It's not usual that the local council will have a lot of say in your pharmacy practice, but it can happen, and with certain outbreaks of healthcare incidents lately, you'll understand more about that. Laws can also happen via executive action, and again, these are usually emergency type situations, but you could have a president, a governor, or a mayor pass some kind of executive order that requires you to do something. Then there's regulation, and regulation can happen either at the federal level or the state level. And just to give you an example, that could be the DEA, the FDA passing something. That could be your state board of pharmacy passing something, the Department of Community Health passing something. But from time to time, federal and state laws will be passed through regulation. And regulations usually just clarify something that was passed in another law. And then there's judicial action, and that is usually the court's interpretation of some type of law or regulation. So the way this process usually happens is the legislature, in some form or variety, will pass a law. That law then gets passed by the executive branch of a particular government in the United States, either the President of the United States, as an example, or the Governor of Michigan. Then those laws get further clarified by a regulatory body. Now, an executive order, in comparison, is signed into law, usually has an immediate effect, and then it gets clarified by regulation if needed, and it's usually implemented as some type of emergency matter. And you'll see an example of one of those in just a moment. So normally what would happen, with the exception of a couple of states that do not have two houses in their legislative body, is one of two houses in your state passes a bill, or in the federal government, for example. So they'll propose a law, those laws get sent to a committee, and that committee will make some recommendations. Either they'll actually tell that legislative body that it likes the law and will send it on to be voted on in its entirety. They will make changes and then send it on, or they will just leave it there forever. And a lot of times, what happens if legislation is really poorly written or it really doesn't have a general consensus, what will happen is the committee will actually just let the bill sit there forever. And there is a legal mechanism in most uh, governing bodies, actually all of them in the United States, with a couple of rare exceptions. But what happens is every 2 years, legislating bodies usually start over with a clean slate. So we just had that happen here in Michigan. At the federal level, we also just had that happen in 2019 as well. So what happened was is at the end of 2018, any bills that were still being considered in Congress or in the Michigan legislature, if they did not pass on December 31st, 2018, they effectively died in the legislature. And on January 1st, 2019, the new legislating bodies that were sworn into office started over. Once one house of a government body passes a law, it goes to the other side. So in Michigan, there's a House of Representatives, and then there's also a Senate, just like you would have in the federal government. So if the House of Representatives passes a bill, it goes to the Senate. If the Senate passes a bill, it goes to the House. Then it gets sent to committee in that particular House. They will either keep the bill intact or they too will make changes. Then the bill is voted on. Now, if there are any changes when it goes to the other house after the first house agreed on something, then it has to go to what is called there's a separate committee that is usually put into place that makes the bill identical on both houses. They basically hammer out their differences and revote on the bills. So it happens frequently in the United States Congress. Happens sometimes in legislatures in other states, especially if two different parties are controlling the two different houses. A lot of times there'll be some disagreement and then they will make changes on the fly to that bill. Now, once the legislating body does agree on the bill and they elect to pass the bill, then it goes to the executive branch for their signature or veto. Now, if the executive signs off on it, whoever that is, be it the governor, be it the President of the United States, if they agree on a law, then that bill is signed and that bill becomes a law. If it is vetoed, it is sent back to the legislature for an override. Depending on where you are and who you have as a constitutional authority, that bill usually requires a supermajority to pass. Usually meaning that 2/3 of both houses or 2/3 of the legislating body must agree to override that law, that veto. Once it's passed, if it's passed, then the regulatory bodies get their fingertips on it. And usually bills are given a period of time for the regulatory bodies to enact them. In the state of Michigan, for example, a bill takes 90 days to become law from the date that the legislature puts their stamp of approval on it. Now, there are exceptions to that. The major exception to that is if they determine it's an emergency. If they feel they don't want to wait the 90 days, they can pass a bill that has immediate effect. And what immediate effect means is that law becomes a law the moment that the governor signs off on it. And then everybody scrambles to make regulations to adhere to it. Regulations, once they are put into place, they can only, one, be made in context with the law, and two, they have to actually just clarify what the legislature is trying to do. And that is the goal of every regulatory body. Uh, they can make rules on their own without the legislature actually making a bill first. And if they do that, they have to do it in context of existing state or federal regulations. So who's on first? Meaning, which law do we actually enforce? The supreme law of the land in the United States is the U.S. Constitution. That means if it's explicitly stated in the U.S. Constitution, the governing bodies all have to adhere to it. Everybody has to adhere to it. It's the law of the land. It is the supreme law of the land. And that's why it's intentionally vague, because if we wanted to make changes to the Constitution, we have to go through the whole amendment process, or we can throw it out and start over. Now, I wouldn't advocate for either one of those because both of those are very timely processes and usually take years and years and years to actually accomplish. Because to change the Constitution requires two-thirds majority of the House, two-thirds majority of the Senate, and three-quarters of every legislating body in the United States. So three-quarters of the states must ratify it in order for it to become law. The last amendment to the Constitution took 226 years to pass. So we don't change the Constitution very lightly in this country. After the United States Constitution comes the United States Code. The United States Code is federal law. Those are laws passed by Congress, usually under some type of authority of the U.S. Constitution, albeit Congress has a very broad latitude of what they're allowed to pass. Once Congress decides a law needs to pass, the president signs off on it, it becomes a law and goes into the United States Code. And then it becomes something that can be enforced by regulatory bodies. And these regulatory bodies, for the purposes of pharmacy, could be the Drug Enforcement Administration. They could be the Food and Drug Administration. The EPA, the Environmental Protection Agency, could be involved. The Centers for Medicaid and Medicare Administration. And when I tell you that that pharmacy is the most regulated profession, you have to consider that between state and federal governments, and sometimes even local governments, there are 26 to 28 regulatory bodies, depending on who's doing the counting, that practice or govern the practice of regulation right down to the Department of Treasury, because pharmacies have to pay income tax because they are for-profit institutions. Now, after the Code of Federal Regulation, that's where U.S. law stops. Anything else that the U.S. government hasn't addressed can be addressed at the state level. And the states have very broad authority under Article 10 of the Constitution, which says, in the U.S. Constitution that should be, Article 10 of the U.S. Constitution says, if anything is not explicitly said here that is a power of the federal government, it's a power of the states. And unlike a lot of other countries, if you look at our neighbors to the north where the federal government has a lot of power, in the United States, the states actually have a lot of power. And that's because, as a country, little history lesson, we didn't want a monarchy. We didn't want to have to fall victim to a tyrant. So when we created our government, we created it so the federal government did not have a lot of authority and the states had a lot more of it. So the states have a lot more power than you think they do. That's why your license to practice is usually issued by a particular state. This is why speed limits are created by each individual state. This is why each state determines what roads get repaired, because they know what's going on in their state. So with a country as large as ours and with a landmass as large as ours, even though we were much smaller when the Constitution was first set out, we decided that the states knew what was going on and determined that the states should have more power. So with that said, most of the laws that'll affect you are usually going to be a state law. The only time the federal government gets involved is once you cross a state line. So if you cross a state line with something, then the federal government automatically gets involved because anything that involves interstate transactions must go through the federal government. States are organized just like the federal government is. So states have a constitution. That's a requirement for statehood. If you do not have a constitution for your government, you do not have a state. One of the interesting things about a state constitution is it even sets out the legal boundaries of the state. It literally defines exactly what defines where the state borders are. And for the longest time, when Michigan was considering statehood, we wrote in our constitution that the city of Toledo, Ohio belonged to the state of Michigan because of the way the Ohio Constitution was written. So when Michigan wanted to become a state, Ohio said, well, Ohio stops at the bottom end of Lake Michigan, where the southern tip of Lake Michigan. Well, somebody measured that wrong, and that started a war. And that's why U of M and Ohio State don't get along. Once a state constitution is established, then the states can make laws. And the states make laws just like they do in the federal government. A couple of states only have one house in the legislature. Some states have part-time legislatures. Michigan is one of the full-time legislature states, so I speak to that a little bit more because I'm familiar with that. Then the states pass a law which gets turned into state regulation. And in very few rare instances, local regulation. Let's say you have a local sales tax on everything that you sell. That local regulation then applies to pharmacy if it's written in that tax law that pharmacy is subject to those taxes. If your city that you live in has a income tax, then your employer, as a local regulation, has to actually withhold those city income taxes on your behalf. So those are important distinctions when it comes to local regulation. Except when one of three things happens. A court can rule a law unconstitutional. Case in point here, this was a Washington Post headline from last year, that a court ruled a portion of the Affordable Care Act, passed in 2009, as unconstitutional. That was the part that said, thou shalt have health insurance. A stricter law is passed. So in Michigan in 2019, on January 4th, the State Board of Pharmacy decided to schedule gabapentin in Schedule 5 of its Controlled Substances Act. Now, that would normally come in direct conflict with the federal law that says gabapentin is not a controlled substance. Now, because the state of Michigan decided to make it a controlled substance in the state of Michigan, because that more strict law exists, we have to follow that. So in the state of Michigan, gabapentin is a Schedule 5 controlled substance. Or an emergency is declared. And an example, this is the New York Times in 2019. New York is experiencing an outbreak of measles as a result of a lack of vaccinations or a lack of vaccine effectiveness when people were first immunized. So as a result, New York declared an emergency and now requires people to get vaccines. Now, that doesn't mean they have to pay for the vaccine. They're requiring you to get it. So you can create what's called an unfunded mandate when you do this, and that unfunded mandate is you're required to go get a measles vaccine. That means you need to go to the doctor and get a vaccine, or you need to go to the pharmacy and get a vaccine. It does not say that insurers are required to pay for it. Most of them do, but not everywhere. So the government is telling you you have to be vaccinated. They are not saying that they're going to pay for it, nor do they say that your health insurance does. So in this particular instance, you're required to get a vaccine and then you're required to pay for it. If you are in a situation where you can't pay for it, sometimes the governments will make provisions to allow you to get vaccinated for free through the health departments of the governing agency that you live in. A law has two very important parts. It has definitions and then the law itself. The definitions contain terms that require a legal definition, and they will do that in context of the law they're trying to pass. I'll give you an example of that in just a moment. The law itself does one of two things. So the law that they write will either change an existing law, which means they are amending the current law that they are trying to adjust to the needs of the current situation. Or they're going to write a brand new law, or they're going to create a new act or a new section of law, which is why when you look at laws, there are purposely places where they leave space to number laws differently. So you have the United States Code is written into titles 1 through 29. And Title 21 is the Food, Drug, and Cosmetic Act. Within Title 21 also is the Controlled Substances Act. And they particularly leave gaps within Title 21 for new sections of the law because they can't think of everything at the same time that they pass a section of law. So they'll leave little spaces where a new law can be inserted if needed. But beware, the devil's in the definitions. And this is where I'm going to tell you to be very careful and read the law carefully. Because a lot of times what you will interpret as something is not how the law says you interpret something. So to take an example, this law. This is under the DEA's Code of Federal Regulations. According to the DEA, the transfer of an original prescription information for a controlled substance listed in Schedules 3, 4, or 5 for the purpose of refill dispensing is permissible between pharmacies on a one-time basis only. However, pharmacies that electronically share real-time online information may transfer up to the maximum refills permitted by law and the prescriber's authorization. This is 21 CFR Part 1306.25 paragraph A, in case you're a law geek like I am and you want to go look it up. But then you read Title 21 of the United States Code, and this is the definitions under the Controlled Substances Act. And I want to draw your attention to a couple of key points in here. It actually tells you the term refilling prescriptions for controlled substances in Schedules 3, 4, or 5, which means they are actually defining what I highlighted in pink at the top of the slide. And that means that the dispensing of a controlled substance in Schedules 3, 4, or 5, in accordance with refill instructions by a practitioner as part of a valid prescription, meets the requirements, but does not include the issuance of a new prescription to an individual for a controlled substance that was previously prescribed. So where people get into trouble when enforcing this particular portion of the law is that a lot of people will actually break the law by transferring a controlled substance that they have not previously filled. So a pharmacy can take in a brand new prescription for lorazepam, which is a Schedule 4 controlled substance. And the patient didn't need it at that point, so they just put it on the patient's file and never filled it. Or the doctor sent it to the wrong pharmacy, and the pharmacy filled the prescription, but the patient doesn't want it at that pharmacy, and they want to take it elsewhere. Well, you can't do that. So whatever pharmacy gets the original prescription must fill the original prescription, or the doctor has to rewrite it. Lastly, and this is one piece of wisdom that I learned in criminal justice procedure when I was taking my undergraduate, ignorance of the law is not a legal defense. So ignorance of the law is no excuse, dummy. and I thought that was actually a fitting way to end this. Keep in mind, I am not a lawyer, so this is not legal advice. This is my interpretation of existing laws that are currently in place. Laws are subject to change without notice. So if you have any questions about the law, make sure you consult an attorney. If it's related to healthcare, make sure you find one that specializes in healthcare law. With that, my name is Adam. This is Drug School. Like and subscribe. If you have any questions, leave them in the comments below. I will answer them to the best of my ability. Uh, Thank you for joining us today. Well,